Multi-generational trusts are created to last. They are designed to protect family wealth, promote fairness, and provide stability not just for children, but for grandchildren and future generations. Yet even the most carefully drafted trust can face conflict over time. Family relationships evolve, financial conditions change, memories fade. And when different generations begin to interpret the same trust in different ways, tension can quickly escalate into legal disputes. I'm Michael Hackard, and over decades working with California families, I've seen how trust disputes in multi-generational trust planning arise, and how deeply they can affect both finances and family relationships. Today, I want to walk you through why these disputes happen, how California law addresses them, and the most effective ways to resolve or prevent them. A trust dispute occurs when trustees or beneficiaries disagree over how a trust is managed, interpreted, or distributed. In multi-generational trust planning, these disputes often surface long after the person who created the trust has passed away. Later generations are left trying to interpret intentions without direct guidance, which creates uncertainty and conflict. Some of the most common issues include trustee misconduct, delayed or unequal distributions, disagreements over investment decisions, unclear or outdated trust language, and disputes over amendments made later in life. Because these trusts are meant to last for decades, even a small drafting flaw or communication breakdown can trigger disputes that span entire family branches. Understanding the root causes is the first step toward resolution. One of the most frequent causes is trustee misconduct. Trustees are legally obligated to act with loyalty, prudence, and impartiality. When they mismanage assets, favor one beneficiary over another, or fail to communicate, trust erodes quickly. Another major trigger is perceived unequal treatment. Even when distributions are technically allowed, beneficiaries may feel that one side of the family is being favored, leading to claims of bias or breach of fiduciary duty. Ambiguous trust language is another common source of conflict. Vague terms like need, support, or reasonable distributions leave too much room for interpretation. Over time, those interpretations diverge. Lack of transparency also fuels disputes. When trustees fail to provide accountings or explain decisions, beneficiaries often assume the worst. And finally, family dynamics matter. Old sibling rivalries, blended families, or unresolved emotional issues often resurface once money and control are involved. California law provides clear legal grounds for addressing these disputes. Under the California Probate Code, beneficiaries may challenge trustee actions based on breach of fiduciary duty, lack of capacity when the trust was created or amended, undue influence, fraud, forgery, or failure to provide proper accountings. These claims must be supported with evidence, and California courts generally encourage resolution before trial whenever possible. When informal efforts fail, disputes move into probate court. The process usually begins with a verified petition outlining the alleged misconduct or errors. The trustee then responds and provides supporting documentation. The case may proceed through discovery, where financial records, emails, and testimony are exchanged. If the matter reaches a hearing, the court can order serious remedies, including removal of the trustee, financial penalties, restitution, or modification of the trust terms. Litigation, however, is often expensive, slow, and emotionally draining. That's why legal conflict resolution strategies for multi-generational trust planning usually prioritize mediation and arbitration. Mediation is one of the most effective tools for resolving trust disputes. A neutral mediator helps the parties communicate, identify core concerns, and reach a mutually acceptable solution. The mediator does not impose a decision. Instead, they guide the process. Mediation allows families to craft flexible solutions that courts may not be able to order. It is private, confidential, and often preserves family relationships that litigation would destroy. California probate courts frequently encourage mediation before allowing cases to proceed further. Arbitration is more formal but still private. A neutral arbitrator reviews evidence and issues a binding decision. Many California trusts include arbitration clauses to ensure disputes remain confidential and move faster than court litigation. Choosing between mediation and arbitration depends on the dispute. Mediation works best for misunderstandings and communication breakdowns. Arbitration is better suited for legal interpretation, fiduciary breaches, or valuation disputes. Throughout these processes, legal counsel plays a critical role in protecting rights and ensuring outcomes comply with California law. Beneficiaries also have strong rights that support accountability. They can request annual accountings, inspect trust records, and petition the court for trustee removal when misconduct occurs. Trustees who ignore these rights risk personal liability. Prevention, however, is always better than resolution. Dispute-resistant trust planning starts with precise drafting. Clear language reduces interpretation conflicts. Trustees should be chosen carefully, based on competence and neutrality, not just family ties. Including mediation or arbitration clauses can prevent disputes from becoming public court battles. Scheduling regular trust reviews ensures outdated provisions do not create confusion later. And open communication among family members helps manage expectations before problems arise. Attorneys play an important role not only in litigation, but also in prevention. Legal counsel can review trustee conduct, mediate family discussions, and step in early before conflicts escalate. When disputes do resolve, outcomes often include trustee replacement, clarification of trust terms, redistribution of assets, or financial restitution. While litigation is never ideal, California courts are designed to protect beneficiaries and restore proper trust administration when needed. Recent California cases reinforce these principles. Courts have consistently emphasized that trustees must follow trust terms strictly, communicate clearly, and document their actions. Transparency and accountability are not optional. The ultimate goal of multigenerational trust planning is not just wealth preservation. It is stability, fairness, and continuity. Families who invest in clear drafting, responsible trusteeship, open communication, and proactive oversight dramatically reduce the risk of disputes. And when conflicts do arise, early informed resolution protects both assets and relationships. Multigenerational trusts can succeed for decades, but only when conflict is addressed thoughtfully and responsibility is enforced consistently. Hackard Law represents heirs and beneficiaries in estate and trust litigation in the San Francisco Bay Area and throughout California. You can call us today at 916-313-3030. We look forward to hearing from you.